impossible to get things fully set up the way you need to. Some people have some of the documents in place, but haven't fully gone through with that planning. And, there may be things we can do, but you need to do them in a timely manner. Things can be too late in this type of planning, and particularly when somebody is completely run out of money after they're already in a long-term care facility. That's where really at that point, there's not much else you can do, because I can't get money back from a facility I've paid, right? They were paid for that service. So it's something that you really need to be aware of when you're going into this situation with a loved one. It's like I mentioned, it's always a good idea to have this discussion early. Welcome everybody. I'm attorney Justin Randall with Hooper Law Office. So our topic today is what to do if my parent or my loved one may need care soon. They may be exhibiting signs of some sort of cognitive decline, or they have other health concerns, and you're just not sure that being at home is what's best for them. And you might need to start looking at a long-term care facility like assisted living or a skilled nursing facility, something like that. There's a lot of things that really you want to make sure you have in place, or you've taken the steps to get prepared for this before that time comes, because there's a lot that you can do to help make that transition smoother. There's a lot you can do to make sure that your parent is more financially prepared for the entire process of that, and that they have a little more choice over the care that they're about to receive, and making sure that they have some money set aside for potentially changes in care needs as well. There's a couple materials we have for you today that are going to be very helpful, I think, in this. We have common errors when helping aging parents with finances. So it's hard to see right here, but it's a full chart of kind of common mistakes that we often see people run into. And then we also have for you red flags when looking at a parent's estate plan. Really, a lot of this is kind of when the discussion isn't being had with your parents, or when they're a little hesitant to talk to you about it. This is where these issues tend to come up the most, because either they're not talking about it because they don't have anything in place, or they're not telling you some of the more important aspects that would allow you to step in and help when they need it. So if you registered via Zoom, you should be getting these materials after this is all said and done. And then a couple housekeeping items before I go too in depth into anything. If you're watching this via Zoom, you should be able to send in questions for the Q&A function here. I'll try to answer them as I see them come up. It's good that this is interactive, because it helps me really know what you guys are looking for help with, and what kind of answers that you might be looking for from this topic today. So yeah, please feel free to send in those questions as I'm going through things. If anything raises any concerns, or you want some more clarification on something, please feel free. Another thing you'll be receiving after this webinar today, if you registered in advance, is that we have a feedback form coming out. The feedback form is really helpful for us. It allows us to improve this process, or talk about topics that you might want to hear discussed going forward. Gives us some ideas and helps us always improve. But the other key aspect of that is, if anything today that I talk about raises concerns for you or for your loved one's situation, and you want to discuss those topics further, or you want us to set up a time to talk with you and your family, via an appointment, there's a place on that feedback form where you can fill in that you would like us to reach out to you to set up an initial consultation. Our initial consultations are free of charge. We don't charge people money to come in and talk to us for those initial consultations, because of how important it is that we set aside time to discuss the topic in full, and we don't want people to be hesitant to come in and do that. They're normally scheduled for about 2 hours. They may take a little less time, or may take longer. It totally depends on the situation, but that's kind of the time frame that we block for them. So that is the one thing I wanted to talk about before I got started here. But with that out of the way, let's get started discussing what to do if your parent may need care soon. With the holiday season coming up, obviously looking different this year for a lot of people, but this tends to be the time of year when people really notice that their parent might need care, or they notice a change in their cognitive behavior, or their other sort of health situations. So it's a time when a lot of these questions come up of, well, what do we do if mom or dad needs care? What, how much is this going to cost? What can we do to make sure that they're taken care of properly and that we have, financial, the financial ability to, give them the care that they need and that they want to have at that time. So first and foremost, as with most things with aging parents in particular, or long-term care type planning, some of the most important things that you are going to want to discuss with your parent is, do you have a power of attorney for finance? Do you have a power of attorney for healthcare? Do you have a living will? Things like that, because with when it comes to aging parents, and if they have any sort of cognitive decline where they can't do things themselves anymore, or they need your assistance, it's really important to have a financial power of attorney and a healthcare power of attorney in place so that that you can step in and help them where you need to. And not all powers of attorney are created equal. What I mean by that is, you can go onto the state statutory website for Wisconsin and download sort of a general financial power of attorney form. And it's better than not having one at all. That's certainly true. But it is a very generalized, very vague document. Yeah, what I mean by that is it'll say things like, do you want to grant someone the ability to have banking powers? But it doesn't explain what that means or elaborate on it at all. So it's important to go and talk with an estate planning attorney and an elder law attorney, ideally somebody who does both, to get a properly drafted healthcare power of attorney and financial power of attorney in place to make sure that you have all of the authorities that you're going to need to help step in and take care of your loved one, and potentially do some long-term care planning for them as well. So that's first and foremost, if that's something you still have the ability to do, absolutely, talk to your loved one about that and have them come in to an elder law attorney's office and have that discussion, because it's critical that you have those documents in place and that they are going to allow you to do what you need them to in order to best take care of your loved one. So assuming though that you have those in place, once that's all taken care of, once that's in place, if you had it taken care of for a long time, what you want to look at is, all right, if mom or dad or both mom and dad are having some declines and it's unlikely that they're getting the care they need at home, or, it's just not the best place for them anymore, you want to start looking at facilities. Everyone wants to stay at home for as long as possible. That's obviously, that's a great goal to have, as long as that's where care is best provided. But once it gets to a point where that's just not the case anymore, you want to start looking at facilities, whether it's assisted living or full skilled nursing. You want to start interviewing these facilities for a couple of reasons. One, you want to make sure it's where your parent wants to be. Does it have the amenities they want? Does it have good food? I mean, whatever it might be, that you want them to have the quality of life that they deserve and what they want. But really, the most important aspect of when you're interviewing these facilities is the financial aspect. Obviously, long-term care costs a lot of money. It's only going up. It's not getting cheaper. And you want to be able to privately fund your long-term care, if at all possible, for at least a couple of years. So, some very important questions to ask a facility are, first of all, what's the estimated monthly cost, which that can vary based off of the care needs for your loved one. But another critical question is, how long does my parent have to pay you privately out of their own money before you will let them live here while receiving government assistance like Medicaid? And that's really important because not all facilities do accept Medicaid at all. Not all facilities accept Medicaid right away. Most usually require somewhere between the 1 and 3 year mark of how much time you have to privately pay before they'll even consider letting you live there on Medicaid. And it's really important to get that information from them, get it in writing, and get a solid date for that. Occasionally you'll see things like, between a facility will say between 1 and 2 years. Well, which one is it, right? I mean, that's a huge difference, especially when you're talking about anywhere between, $5,000 to $10,000 a month in cost. That's a huge difference. So it's important to get that hard number on there. Another thing to bring up with sort of the interview process and finding the right facility for your loved one. If this is hard to do on your own, if it's not something you're used to doing, there's so many different facilities out there. There's so many different things you need to be aware of. How are you supposed to know where to even begin looking? And there are really good organizations out there that their entire job is to help you find the right place for your loved one. They're called geriatric care managers. So they help you interview these facilities, and they can help you find, based off of the care needs of your loved one, how much assets you can set aside for private payment, and what the particular kind of amenities you're looking for. I mean, all these sorts of topics. They can help you whittle down the choice a little bit between facilities and finding the right one for you. Sometimes it's more geographically based in decision if it's where you're closest to. Sometimes it's not as important if you're willing to go visit your loved one farther away. I mean, obviously we're still talking in the area, just whether or not it's in your own city is maybe that's not where the best facility is for your loved one. But really, you want to make sure that your mom, your dad, or your loved one is getting the care that they need. They have the quality of life that they want, as much as that's possible, and that it fits your financial parameters as well. You want to make sure that you can afford to privately pay for the time frame that they require. The reason for that, obviously it is expensive, and that private payment is going to dip into assets a bit. I mean, if you're talking about a 2 to 3 year time frame, you're potentially looking at at least $100,000 or a couple $100,000 in terms of assets, and that's no small chunk of change, obviously. So it's important to at least look at that first and look at that cost of care first to make sure that if it's something that your parent can do, that they find a way to do that efficiently and receive the cost of care, or the type of care that they need. You want to be able to afford it because it gives you more choice. As with anything in life, if it's something you have the ability to pay for, you are going to have the widest variety of options. Meaning, do I really like this facility, or is there one that's slightly more expensive, but I can still afford, but it has all the amenities I want, it's closer to home, whatever it might be. So it's really important to have that information and know full well going into it exactly what that is going to look like to make sure that your loved one is able to. Obviously, not everyone is. That's, a lot of people do have to look at, well, I can't afford a private payment for that long. And there are some really good facilities that accept Medicaid right away, but it just limits your options. There's not as many of them as the ones that require private payment. So if it's something that you can do, it's important that you do. Another thing to consider here is not just that initial private payment requirement, but what do you do when your loved one's care needs change? So if you've made it through that private payment period of 2 to 3 years at an assisted living facility, one that maybe doesn't have memory care, what do you do if your parent suddenly needs memory care and actually needs to change facilities? Well, depending on how much in assets you had available, if you've actually spent down all the way from that initial private payment requirement all the way down to where your loved one qualifies for Medicaid, you now have to look at, well, where does this money come from to have another private payment requirement met at a new facility? It's not just that initial payment that you need to be aware of, but it's also this potential secondary payment at a new facility of another 1 to 2 to 3 years. This happens for a variety of reasons. I mentioned one. It can happen for a change in types of care that is required for your parent, memory care versus not having memory care available. But it can happen for, financial reasons on the side of the facility. Just this year, during the past year, a facility closed down. And a lot of people in that facility may have privately paid. They may have been on Medicaid at that point. And now they're required to go to new facilities because, that one is just no longer operating. So a lot of those people would benefit from having an ability to privately pay again and having some assets set aside for that so that they are able to get into the next facility of their choice, whether it's due to healthcare changes and higher need of care that your current facility doesn't have, or whether it's due to kind of outside circumstances where it's nothing you can control and it has nothing to do with you personally, but the facility went out of business. This does happen. So it's just something to be aware of. Hopefully this never happens to somebody where they don't have to privately pay more than once at a different facility, but it happens enough where if you don't have that ability, it could be an issue. So how you do that is, if your loved one needs care, you need to go talk to an elder law attorney as soon as you can. For example, all of us here in our office are elder law attorneys and estate planning attorneys. Ideally, you would find somebody that does both estate planning and elder law. This area kind of is where these two kind of different topics of law really come together very well. So that estate planning side can help you get the documents in place that you need, like powers of attorney, trusts, wills, whatever it might be. But the elder law aspect is the side where they're going to really be able to help walk you through the requirements for Medicaid, helping make sure that your loved one has that sort of second pot of money set aside in a way that is not available for Medicaid, but allows them to potentially have that quality of care or the choice over their quality of care for a second facility. So, this is not something you want to wait to do. The sooner you do it, the more options you have available, and the more money you have available to plan around. Even if your loved one is already receiving care at a facility, it's still not too late unless they are already spent down to pretty much, Medicaid levels where they are on Medicaid currently, especially if you're talking about potentially here a single individual down to that $2,000 roughly, amount of assets that they're allowed to have. At that point, there's not much you have in terms of leeway to play with in terms of setting extra money aside. But if your loved one has been in care and still has assets that they're spending down through, there's still things you can do. So just absolutely the best advice you can get is don't try to do this alone. Always go in and talk to, a variety of professionals with this. If you don't have a relationship with your parent's financial advisor or their estate planning attorney, ask your parent and sit down with them and see if you can have this discussion and have that sort of joint meeting so that you're better able to step in and help them at that point. Funding long-term care is not just about one spouse, right? So where some of the more intricate planning comes into place and where more considerations need to be included in the initial planning is when one spouse needs care but the other spouse is healthy. A healthy spouse, while one spouse is receiving care and is on Medicaid, is allowed to keep a lot more than you would necessarily be allowed to keep with just a single person on Medicaid. But it's not just what are you allowed to keep while your spouse is on Medicaid, it's what happens when that healthy spouse needs care as well. If you spent down through a bulk of the assets to get one spouse qualified for Medicaid, but the healthy spouse then needs care at some point, well, the key here is trying to equalize the amount available for each spouse's care. In particular, when it comes to retirement accounts of the healthy spouse are not countable for against the spouse receiving care in a long-term care facility for Medicaid purposes. But if that spouse receiving care is the one with all of the retirement assets in terms of IRAs, 401ks, things like that, well, they're going to have to spend through the bulk of maybe the assets before they can receive care, or assistance from Medicaid. And if the healthy spouse is the one with very little in terms of qualified retirement accounts, they're only allowed to keep so much of those assets that are otherwise available, they're not going to have nearly as much available to go through a private payment requirement and get the care that they deserve as well. So that's where an elder law attorney is really going to be able to help you look at the entire picture, working with your financial advisor on this as well, and looking at the whole picture and saying, here are the assets in front of us. Here's the type of care mom or dad needs, or maybe both mom and dad need. And here's what we can do to both get them the initial, through that initial private payment period if possible, and also set aside some assets so that if they need that second private pay period at a new facility because of care changes or the facility goes out of business, you're able to have that discussion well in advance of ever actually needing to go through with it, right? Which is always going to afford you the biggest opportunity to protect things and save your parent the most amount of money and make sure that they're taken care of. With this, that being said, it's obviously always better, not to wait until your loved one is even close to needing care to do this type of planning. Ideally, you would do this planning, talk to an elder law attorney with your parent, make sure that they have what they need, ideally 5 or more years in advance, right? That provides you as much time as you need to do that planning, to make sure that they're protected and make sure that they have the documents in place that allows you or somebody else that they've chosen to step in for them, allows that person to make the decisions they need to make and to help them when they need it. So it's, as with anything, prospectively doing something is always better than doing it last minute or after the fact, because it's just, you have a lot more time available to do the proper planning well in advance. But if the care is needed sooner rather than later, that's where it's even more essential to get in as soon as possible and talk to an attorney and make sure that you're talking to an elder law attorney, somebody who focuses on that area, not just kind of somebody you've gone through for a lot of like real estate transactions or something like that. Not because they're not really good at doing that, but because they're not necessarily versed in the area that you need. It's just like going to a heart surgeon for neurosurgery. It doesn't necessarily overlap, right? Those are very different things. So some common errors that come up a lot with this, planning in general, but in particular, if you're concerned about your parents' care, is first and foremost, just not having the discussion. There's a lot of parents who you really don't want to talk about these things for possibly a variety of reasons, right? One, it's not a topic a lot of us like to discuss, us aging and needing care at some point, or kind of being aware of our own mortality. It's not a fun topic of conversation, but it is a necessary one. So setting aside that time to sit down and say, look, mom, dad, what documents do you have in place? You don't have to necessarily tell me who's inheriting what, but just tell me, where do you keep your financial assets? Who's your advisor? Who do you go to for, your legal, estate planning advice, if you have an attorney that does that? And do you have a properly drafted power of attorney? Can I see what I'm allowed to do, right? Because having that discussion in advance is going to make you just that much more prepared and aware if you need to change something before it's too late. The worst thing that you can do is wait until it's too late, where your loved one doesn't have these documents in place and they've lost capacity. They don't have the ability to sign new legal documents because of not having the ability to understand what they're signing, right? At that point, if your only option left is going through a process known as guardianship, where they just didn't have capacity to sign a healthcare or financial power of attorney, that guardianship process is not going to grant you the same level of authority that you may need to fully plan for your loved one at that point. When you plan in advance, you get a custom drafted, financial power of attorney with all the authorities that you need for long-term care planning and potentially emergency situations. You're always going to have more authority that you need than what a court is going to grant you. So it's just that much more important to get it done in advance. Another thing we see a lot of, for example, is when people are using joint accounts with their parent. That is a problem for a number of reasons. One, if you're doing it because you think that that's going to protect against long-term care or it's somehow not going to be available, that's not necessarily true, right? If it's still considered at least partially the asset of the person receiving care, at least some of it's available. But the other aspect is it's not good for their estate plan. So when somebody is a joint owner on a bank account, for example, even if you're using it to pay bills, whether during their lifetime or at death, that joint account does not go by the terms of their will or their trust that they may have had set up. It instead goes directly to the joint owner that survives. So that just means now that the other child or loved one that was on as a joint owner is now the full owner of that account, which means a couple of things. I mean, yes, they have the ability to pay expenses, certainly, but it may not be what the estate plan was set up to do. If you had everything going to your kids equally, but then it only all went to one because they were the joint owner on everything, well, they're now, one, no longer obligated to give that to all of their siblings. Two, they may not be financially able to do so because of their own financial limitations due to maybe they are receiving Medicaid or SSI, disability income, something like that. They may not be able to either. So whether it's out of selfish greed that they're not sharing it, or just because they are unable to for legal reasons, you're not giving them a lot of options in terms of what can you do to actually enact mom or dad's wishes if they're in either of those situations. So the best way you can make sure that you're taken care of is that all of your assets go by the term of your estate plan, which is by not having them owned joint ownership with your child or another loved one. This is common advice that we do hear, being given by maybe somebody meaning well. Maybe it's somebody at the bank or somebody at on the phone with them at the insurance company or investment company, whatever it might be. But the issue is that as well intentioned as it might be, it still causes issues. So that's really important that, if you're trying to protect things, there are better ways to do it. And if you're trying to make sure that somebody has the ability to access those funds after you're gone to pay final expenses or to pay off creditors, there are better ways to do it. And that's where someone, who's an estate planning attorney or an elder law attorney can really help you out there. Another thing that comes up a lot, especially when there's concerns about long-term care, is how do I protect things, right? And I mentioned already that someone like one of the attorneys at our office would definitely be able to help you there. But what people often try to do on their own is you hear the common situation of, I'm going to gift or transfer the home over into the names of my kids, or I'm just going to start gifting away assets over time to my kids, and I'm going to keep it below that $15,000 per person per year. That I'm allowed to give through the IRS. So there's a couple of really big issues with those. One, any gift that you make, regardless of whether you're staying within the IRS's gift tax exclusion, the $15,000, even if you're staying within that, Medicaid doesn't care. Any amount of gift that you make, in theory, is a countable gift for Medicaid. It will be counted as a divestment if you need care within the next 5 years. So if you're doing it knowingly and you're doing it with all of those risks associated, and you've made the informed decision on it, that's one thing. But doing it thinking that you're somehow protecting it because you're within the IRS exclusion, that's a mistake, and it can be costly, especially when someone is trying to protect assets through emergency planning when a loved one is going into care and you haven't had potentially the 5 years or more in advance. Gifting the home over to the kids is another big issue that we run into a lot, or that kind of thinking is a big issue. One, it's still a divestment for Medicaid if it's done within the 5 years before care. But two, it's not really a great way for you to maintain control if you're the parent in this situation. It's not a great way for you to maintain control over your assets as you age. The biggest loss of control you have is to literally give something away to somebody else and have it be owned by them. And hopefully your kids are not the types of kids that would, evict you or charge you rent to live in your own home. But, it just highlights that technically they would be well within their legal right to do so. So keep that in mind. I'm not saying anybody's kids will hopefully ever do that, but it can happen. Another thing is if, it's bad tax planning for them. Or for you to do for them, because if you gift your home over to them, your cost basis in the home, essentially think of it simply as a way to say, okay, this is what I bought my home for when I bought it. So if you bought your home in 1960 for $50,000 and today it's worth about $200,000, well, if you gift your home over to your kids, the IRS is going to say, well, they paid $50,000 for it, essentially. So that means when they turn around and sell it, they are going to receive it, a tax liability for that, a capital gains tax liability. A way to avoid that is to pass it through your estate plan, because then it gets adjusted to the fair market value when they receive it. So there's a couple things that can clearly go wrong with gifting the home. There are better ways to protect it if that's something you want to do. I'm running a little short on time here, so I won't keep you guys too long. But I think just kind of the fact that there's so many different things that can go wrong with this type of planning, especially if you try to do it on your own, just highlights the incredible need to go talk to people who know this area, whether that's an elder law attorney, estate planning attorney, your financial advisor, or somebody who can help you select the right facility if your loved one needs care. All of these things combined, you guys are not expected to know how to do this on your own, but it's that much more essential then to come in and talk to somebody while you still have the ability to do so, or prior to your loved one needing care, or while you can still do something to set aside some money for them and protect them from spending down to nothing. Again, if anything today raised any concerns for you or your loved one, and you would like us to reach out to you to set up a time to talk, please fill out that feedback form and notify or mark that you would like us to reach out to you. We won't reach out to you otherwise. We need that permission from you. So if you would like us to, please mark that you would, or go ahead and call us to set up a time to talk with one of our attorneys. But otherwise, I hope you guys have a good rest of your week, and